Before this courtroom session even begins, what you're about to witness is a powerful reminder of how quickly someone's life can spiral when addiction and legal consequences collide. Today's case brings two very different defendants into the same courtroom, but both are facing the same brutal reality. The judge's patience is running out. First, we'll see Kenzie Dunn, a defendant asking the court for one more chance to enter treatment after testing positive for drugs. Her attorney argues that she's trying to address the root cause of her behavior. But here's the problem. The judge wants proof, not promises. And then there's Lita Thompson, someone who claims she slipped up during a moment of grief after losing a close friend. Her defense paints a picture of a hard-working woman juggling two jobs, attending recovery meetings, and trying to rebuild her life. But even one mistake while under court supervision can have serious consequences. The real tension here is this: when does compassion end and accountability begin? Judges see these cases every single day. Defendants promise change. Attorneys ask for mercy. But the court must decide whether those promises are real or just another delay. So, as this hearing unfolds, pay close attention to the judge's questions, the defendant's answers, and the critical moments that determine their fate. Because by the end of this hearing, both women will learn a harsh truth about the justice system. Good intentions don't always stop the consequences. Let's step inside the courtroom.
Court calls the case of the people versus Kenzie Dunn.
Michael Gaddy, Assistant Public Defender, on behalf of make your way to the podium.
Your name?
Oh, I'm sorry, Kenzie Dunn.
Your Honor, I have submitted a green sheet. We're asking for an adjournment. Ms. Dunn has a assessment at the Sacred Heart treatment facility tomorrow. I do have verification here. It's the Sacred Heart program that's up in Richmond, which I think is up in northern Macomb County. It looks like it's their model is a 12-step type approach. It is inpatient.
On an amphetamine of some type?
Excuse me, Judge?
On an amphetamine of some type?
You mean prescribed?
Have
Yeah, I don't believe so, Judge.
Right here is where the courtroom dynamic begins to shift. The judge isn't just listening to the defense attorney, he's evaluating credibility. When someone appears in court asking for more time or treatment, judges often focus on one key factor: personal accountability. Notice the judge's question about amphetamines. That's not a small detail. Drug tests are often one of the most concrete pieces of evidence in cases involving substance use. If a defendant claims they're seeking treatment but still tests positive, the court may question whether they're truly ready to change. And here's the legal reality. Treatment programs can absolutely help defendants avoid harsher penalties, but only if the court believes the person is serious about recovery. So the judge's skepticism here isn't unusual. Courts hear promises all the time. What they want is proof. The big question now becomes, will the judge give her the benefit of the doubt or decide that the risk is too high?
This should be clarified. So why is she testing positive for amphetamines?
Your Honor, I believe this was the initial test after arraignment. We are asking for an adjournment.
Will she test clean today?
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
I think she's, it's my understanding she doesn't know the half-life of it, Your Honor. I believe her initial test was
That was she
the 6th
saying?
or the 5th. Well, she
When's
said,
the last time did you use?
It was a couple days ago. That's why I'm seeking in-house treatment. Your Honor.
Your Honor, I do have documentation here that she is seeking to address the root cause of any of this behavior. Like I said, she has an intake tomorrow. I can, it's at 1 p.m. That's enrichment. She is here, this issue today. I can offer to the.
If she tests on the 6th, she's positive on the 6th. I'm now here on the 12th, and she's using by the 10th. I have no guarantee that she's going to make it even to treatment.
Yeah, I promise you, I will have my 4 kids with me, sir, Your Honor.
You know, she has a lot at stake.
I understand that, including her life.
Yeah, sure.
I'll adjourn the probable cause conference, March 19, 2026, 9 a.m. This time the
That
defendant's
decision
bond
right
is
there is one of the most difficult and controversial choices judges make in cases like this. Even though the defendant asked for treatment, the judge ultimately revoked her bond and ordered her into custody. Why? Because the court determined there was no guarantee she would actually follow through with the treatment program. In the legal system, this comes down to risk management. Judges have to consider several factors: prior behavior, compliance with court orders, drug test results, and whether the defendant might continue using substances while free. From the judge's perspective, waiting another week while hoping she goes to treatment could create additional risk. But from the defendant's perspective, it might feel like the court just took away her chance to fix the problem. And that raises an important question for you watching this case. Should courts prioritize giving people the opportunity for treatment, or focus on strict accountability when someone repeatedly violates conditions? Let me know what you think in the comments.
This time the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Laquita Thompson.
People.
And Assistant Public Defendant Nick Vukovich on behalf of Ms. Thompson, who's now approaching. Can you please state your name for the record?
Laquita Thompson.
What are we doing? You're seeking an adjournment?
Yes, I am seeking an adjournment, Your Honor. And I'm prepared to address the corrections report.
Pardon?
I said there was a note for community corrections reports. I'm prepared
Yes.
to address that.
And on February 22nd, she blew numbers. We're at her 3 blows, then she took an EEG the next day. It came back.
Yes, Your Honor.
This courtroom session leaves us with 2 powerful stories and 2 very different emotional outcomes. In the first case, Kenzie Dunn asked the court for time to enter treatment, but her recent drug use and uncertain compliance led the judge to revoke her bond and place her into custody. The court simply wasn't willing to gamble on whether she would follow through. Then we saw Lita Thompson, a woman who admitted to drinking after losing a close friend, something her attorney framed as a moment of grief rather than a pattern of defiance. Despite evidence that she was working 2 jobs, attending recovery meetings, and trying to rebuild her life, the judge ultimately decided that the violations were too serious to ignore. And this is the difficult balance courts face every day: compassion versus accountability. Should judges prioritize second chances for people trying to recover, or enforce strict consequences when court orders are violated? There are strong arguments on both sides, and cases like this show just how complicated those decisions can be. Now we want to hear from you. Do you think the judge made the right call in these cases? If you found this courtroom breakdown interesting, hit the like button share your thoughts in the comments, and don't forget to subscribe to Crime Docs for more real courtroom stories and legal breakdowns. Because sometimes the most dramatic stories are the ones that happen in real-life
Sure.
courtrooms.
In addressing the alleged violation, my client does admit to drinking on that 22nd date. It was unfortunately she did lose a friend of 24 years, someone she worked for and has known for a very long time. And unfortunately, as part of the grieving process, she does admit she did have a moment of weakness and there was a mistake and she did drink. She is working very hard on maintaining the good strides she has made in her life. She currently works 2 jobs. One where she works approximately 12-hour shifts on her feet at a manufacturing factory. She has done community service. She attends AA meetings. I actually do have AA sign-in sheet that I can provide to the court and the prosecution. She attends them both in person when she's able to and on Zoom when her work schedule does not allow her to make in-person dates. I do want to note, prior to being placed on the prior to being placed on the sober link, she did have no violations on the Scram tether. She had to be placed on the sober link due to issues with her ankle, and that was why at the previous PCC date you allowed her to switch over to the sober link. I do note I do understand there are several late tests. However, I do want to note several of those tests she did test within 10 minutes after the time frame occurred. I think 7 of those total. And for all of those late tests, she was negative. She does, as I indicated, work on a manufacturing line. So sometimes there are moments where she cannot physically step away from that line due to the ongoing working process, as it would be obviously a process issue for the process of work, but also for safety down the line. She has indicated that she has reached out to her supervising agent to discuss these matters when she does have a late test. She is actually working on obtaining a house and was actually supposed to assign on that house today. She is doing a lot of work to improve her life, continue doing what she must. And I think it is clear that she is attempting to do with everything within her power to comply with the bond conditions. So at this time, Your Honor, I would be requesting that she have a second chance and that her PR bond be maintained.
Any response to the people?
My concern, Your Honor, is that we kind of was on a tether and we agreed to change her to a sober link. Now she has these issues.
Yep.
And it was right about in the graciousness of the court to modify those conditions. So, near as I can see, there's an option.
Oh, what's that option? Lock me up?
I will adjourn the probable cause conference to
I have-
March 19, 2026, 9 a.m. Defendants bond
Jobs.
time, having it
Oh
filed.
my God,
Both defendants remanded.
I have 2 jobs. I have 2 jobs. I got, oh my gosh.
Want me